Good day, sir.
Good day.
Yeah, we are pressmen from Biafra writers. I'm glad to meet you today.
Same to me.
Yeah.
Don't mind.
Thank you. We can see you're brightened up. So it seems as if there's a positive outcome today.
Well, actually, we have every cause to be happy because we're not moving at their own pace. We want them to move at their own pace because their plans and their design is to ensure that they do everything humanly possible to convict our client as soon as possible, which we are trying to see how to correct it.
Okay.
We're making certain effort to that effect.
Okay, last court sitting, I think that should be on 7th of March. The decision of the court was really, it arose several discussions, both here in the Nigeria environment and beyond. So what actually do you think is the position of the judge in respect to his previous decision?
Actually, we are all taken aback because I've not seen such thing since my practice as a lawyer. The court on the 19th day of February made an order based on application they brought before the court to hear our clients in camera. That is to bring masquerade to come and testify in form of human beings. You understand what I mean by that? So this application we vehemently opposed, and the court only granted what they call relief 1, 2, 3. So they have about 5 prayers in the application, and the 5th one borders on bringing witnesses to testify using facial mask and to stand behind the screen. And this application we vehemently opposed, and court upheld our objection and granted the relief 1, 2, and 3. The relief 1 borders on addresses and names of the prosecution witnesses. The relief 1 was granted to the extent that the names and the prosecution witnesses will not reflect in the record of the court for security reasons. So then the relief 3 has to do with them coming through unconventional ways and doors, so which we have no objection. And so far as they're coming to give testimony before the public, and we'll see them, ask them questions, we don't have a problem with that. So we are taken aback when this one came up on 7th of March. They orally applied to the court to vary an order the court made on 19th of March. It's strange in our practice because if you are uncomfortable or dissatisfied with order made by the court or ruling of the court, what you will do is to go to court of appeal. There are few circumstances under which court will vacate an order made by him, and those circumstances are not in existence in this present case.
Okay.
And there's no reason why court in the first place should grant that clarification orally. Because if you see the effort made by the court to smuggle in giving testimony by the witnesses behind the screen, relying heavily on relief 3, you will notice that a thorough look at relief 3, there's nothing like screen giving testimony behind the screen in relief 3, which the court granted. So trying to smuggle in giving testimony behind the screen to make it part of the train is what you objected, and it amounts to court sitting on appeal in his own case. And so as I stand now, what I feel against that order, and we are court of appeal now.
Okay, the judge, I think he made reference of an event in Ivory Coast, and I think some of you argued that. Can you throw more light on that? Because I think so many persons want to.
The court came back on a flurry of his own.
Okay.
Because you don't adopt somebody a legal system or what's obtainable in francophone countries to our own legal system, which we're able to explain to the court, because it's not applicable to our own system. So the court is on its own flurry as far as that issue is concerned, and it has no application to what's our business before the court.
Okay. So why is the court decision today? How did it go?
Well, the most important, this kind of case have to be on the ground, and they work seriously that night to ensure that they give their client best representation. The court was prepared this morning to take their witnesses behind the screen, as directed last week. But only yesterday we filed a notice of appeal against that order. And this morning we filed an application for stay of proceedings, pending the resolution of the appeal before the court of appeal. And that was the application was served on the prosecution this morning. So in the circumstance, they asked for a date to respond. And the issues raised in the appeal from borders of constitutional issues, which we are firm conviction that the court must certainly await the decision of the court of appeal on appeal before the court of appeal, because if court decides to proceed with the hearing of this application, this charge, without reference or without regard to the application we have for the court of appeal. That means it will certainly, in one way or the other, render whatever will be that court of appeal decision not get.
Okay. So was the defendant in court today?
Yeah, he came. Of course, he came.
Okay. How did he feel?
He felt very happy. He was happy because he apparently was happy.
So I think we probably heard in the last case that should be on the 7th about issue of life threat. Please.
There was kind of a brief kind of altercation between us and the members of the SSS. You know, overzealousness on their own part. There was a existing order of court that members of the public should allow to come and participate in the proceedings. That order has not been accepted. I made it known to them, and the order was well explained. At the date the ruling was delivered, the members of the public should allow to come. Members of the actual family of the defendant should come and be part of the proceedings and witness what's happening in the court. Then until when the courtroom is filled to the brim, that's when the court says, okay, they should stop coming. If the capacity has exhausted, then the people will stop allowing people in. But I was shocked when we have about 10 or 7 or 8 persons in the court. Chairs were empty. I went downstairs to tell them that last further people to come in. They started assaulting me. At the point, one of them threatened to kill me.
Wow. And
this issue was laid before the court. And in his usual manner, the court only took note of that and never admonished them or cautioned them. So these are things we see we practice. He's only interested in protecting the interest of the witness who are coming to give a tailored evidence, as opposed to a lawyer whose life has been threatened.
So what is your reaction to the actions of the court?
Well, as far as I'm concerned,
in respect to your life threat,
as far as I'm concerned, we are of the firm view that our client cannot get a fair trial in this court. And part of the review before the court of appeal now is for the court of appeal to direct the CJ, honorable CJ, to transfer this matter to another court for fair trial. From the way and manner they are conducting trial, we have the firm conviction that this matter they will not get a fair trial in this court.
Okay. Finally, sir, what is your challenges so far?
Yeah. Well, we have no challenges. It's one of those things. Situation whereby people will be flouting orders of court. At least you are familiar with the history of the case.
Yeah.
When he was arrested, the time court directed that he should be released unconditionally. Even when court decided that acquitted him, they still heard him without releasing him. So we know that what is happening around him is more than meet the eye. So we know that there are some people's hands are working, but we believe in justice and we believe in justice and know that nothing more than nothing except justice will happen.
Okay, there are millions of Biafrans all over the world, and I think most are really optimistic that you are going to give us a positive, result at the end of the entire scenario. So, what do you have for them?
Well, I'm hopeful that anyone from now there will be a fruitful result from court of appeal. As I speak to you, we filed a petition challenging their bail refused by the High Court, by the Federal High Court. So tomorrow the matter is coming before the court of appeal for hearing of application to abridge time. And today they serve us their own respondent brief. So that has made our case very easy. So by tomorrow the court of appeal will give us time within which to file a reply brief and hear application for their bail on the merit. And based on the past present for that court of appeal will exempt bail. And once they are on bail, you see that the entire system, the entire scenario will change.
Okay, thank you, sir. We are glad to be with you this moment, and we look forward to equally have more audience with you. Thank you. We are from Biafra Writers, and we are more appreciated to your responses. Thank you, sir.
We need your prayers and your encouragement in this kind of struggle. We have to only focus on God and Chukwu Abiyama, because I know that without having challenges one way or the other, people will be looking for a way, possible of getting you out of the way. But we believe in the truth, and I know that God is always with us.
Okay.
Thank you so much.
Thank you, sir.
Thank you, sir.